Thank you, JP. Good evening, Judge Rogers.
Good evening, Chief Justice.
How are you, sir?
I'm trying to look where the people are.
You won't find me there.
Oh, I see. All right. Yes, I'm apprehensive, but I'm as ready as I'll ever be.
All right. We apologize to you for keeping you waiting this long.
No, that's quite all right.
Thank you. For how long have you been on the High Court bench?
From January 2013, so I'm going into my 8th year now.
What about the Competition Appeal Court?
I was appointed permanently there in January 2017, so that's been about 4 years. I did act as an AJA there for several years before.
And for how many terms have you acted at the Supreme Court of Appeal?
My application says 6, but I am acting there currently for the first and second terms. So at the end of that period, it will have been 8 terms in total.
And tell us briefly how ready you are for the SCA.
In terms of being able to do the work and make a contribution, I believe I am ready. Through 8 terms there, I've found that I have been able to cope with the reading work, prepare well for appeals, work well with colleagues in finalizing judgments, also in dealing with the petitions that come our way. So in that sense, I am ready, I believe, and I do think that I can make a contribution there.
President, before you come in, President, let me just take the names of colleagues who are going to put questions to Judge Rogers. Colleagues?
Bofu, Matonsela, Muimang,
Tepe.
Barnard.
I don't know whether you heard Schlemmer.
I wonder if it might be possible, just before other questions are asked, if I make 1 or 2 corrections or supplements to the information I provided.
Go ahead, Judge.
Yes. In the standard questionnaire in item 12, I omitted to mention an article that was published in 2019 in The Advocate. Its title was Argument and Opinion, Advocate and Expert, and it was a treatment of the ethical problems that advocates may have to confront when dealing with expert witnesses. In item 15, the book that I published, I'm sure it might have been more interesting if it was about a conspiracy in 1989, but it was in fact a conspiracy in 1895. In regard to the reserved judgments mentioned in 16.5 of the questionnaire, the Camps Bay judgment was delivered on the 15th of December, and the other 2 cases both on the 2nd of December. Yes, there are a couple of judgments I missed out in my list of cases, but I don't think you need to know about them. Thank you.
Thank you very much, Judge. President? President Maya?
I am here, CJ, sorry. Judge Rogers, good evening.
Good evening.
We interviewed you for the same vacancy just 2 years ago, so I don't really have any questions for you. I think you persuaded me that you are ready, to join the SCA, and you have a tremendous contribution to make, to the court then. I'll just point out that we have actually invited you back now for this extra 2 terms, precisely because of the contribution you make. And I know that you published a book in the meantime, Lawyers in Turmoil, which you just mentioned now, and I'm still struggling to finish it. I don't have time. It's a thick book, but very, very interesting. Well done on this. I just want to raise one issue with you. This complaint that has been lodged against you by attorneys, Kulu attorneys, I'm not quite sure what they are called, with the JCC. Am I correct that its essence is that you refused Mr. Kulu's application for your recusal in one of his matters?
Yes, I don't want to, unless the Chief Justice indicates otherwise, wish to discuss the merits of
To
that.
go into the
complaint.
merits, I understand that.
It's a complaint against 10 judges, of whom I am one. It arises it has its genesis in allegations that Mr. Kulu made in an affidavit for my recusal in a case where his firm was personally a litigant.
Yes, that's all I want to confirm. Now, should that complaint, yes.
May I just add that as far as I know, the complaint was submitted by Mr. Kulu in mid-February. The 10 judges have received no communication from the JSC about that complaint. I know informally from inquiry that it has been received, but we have received no communication about it. We haven't been called upon to answer it.
All right.
Or at least not yet.
Okay. Well, is there any reason why that complaint should stand in the way of your appointment? It is there. We may not know precisely what it's about, but it is there, and it's something that weighs heavily on one's mind. What should we do about it?
I'm personally absolutely persuaded that if you knew the circumstances and the facts, you would not attach any significance to the fact that the complaint has been lodged. It is against 10 judges. I am the second most junior of those 10. The other include Judges Davis, Meir, Bozalek. They are all judges of repute. We took great offense at allegations that Mr. Kulu made about us in an affidavit for my recusal. And in December last year, we lodged a complaint of professional misconduct against him with the Legal Practice Council. Although there was some delay, in March of this year, the Legal Practice Council has ruled that there's prima facie evidence of misconduct in accordance with our complaint. And Mr. Kulu has been called upon to respond to it. That complaint is before the LPC. The complaint that he lodged against us with the JCC came about 2 months later. And I believe very confidently that if I were able to tell you the circumstances, which I could do in a very few minutes, and which I would not dream of telling you one thing false, because this is a very public forum, you would be absolutely satisfied that you should not attach significance to it. But more than that, I'm really not in a position now to say.
Mm-hmm. No, that's enough for my purposes, Judge Rogers. Thank you. Thank you, CJ.
Thank you, President. Commissioner Mpofu.
Thank you. Good evening, Judge. I'm this side. Yeah.
Yes, good evening, Mr. Mpofu.
Good evening. Justice Rogers, I would just want to ask you one thing. But let me preface it by saying that, as a practitioner, maybe for the benefit of the people who don't practice in the courts, that I think it would be fair to say that the quality and quantity of your work speaks for itself. And it is of a very high standard. Now, having served the periods that you have mentioned here in the different courts, SCA, CAC, and then the High Court, you represent, at least to me, the opposite of what we said to one of the candidates in the Constitutional Court interviews. In that the kind of work that you have done would, in my estimation, be of some significant value to an institution such as the Constitutional Court. If I may ask you, I know it's an awkward question, is there a reason why you did not apply for the Constitutional Court and preferred the SCA when, at least this round, there were vacancies in both courts as opposed to the last time you were here?
Mr. Mpofu, what I can firstly say is that I have no intention of seeking or putting myself forward for the Constitutional Court. I haven't acted there or been invited to act there, so I can't speak from personal knowledge. But my impression from speaking with people who have been there and from other anecdotal information, I believe my talents are perhaps better employed in a generalist court. I appreciate that now the Constitutional Court can hear non-constitutional matters of public
Yes. Of general
public importance. But nevertheless, the fact remains, for example, that the majority of generalist work will be decided at the SCA. And I feel that my skills are more suited to that. I work quickly through a lot of material. Although I did a certain amount of work in the public law sphere as an advocate, and I've done my fair share of reviews as a judge, I wouldn't say that at the bar, when somebody was looking for a top person to go to the Constitutional Court, I don't think my name wasn't the first on their list. And perhaps I've got less of a feel for it than I do for the general work.
Okay. Thank you. You do appreciate, though, that obviously you do that the Constitution permeates any other work, even the work that you'll be doing in the SCA. But I get what
I perfectly understand that.
Yes. Thank you. Thank you, Sir.
Thank you, SC. Commissioner Madonsela?
Thank you, Chief Justice. Good evening.
Yes, good evening, Mr. Madonsela.
My question actually is related to the question that Mr. Commissioner Mpofu has asked you. The question is really, now that we have in the hierarchy of appeal courts, we have the High Court, sometimes the full bench, as an appeal layer, the SCA, and then the Constitutional Court. What do you regard the role of the SCA to be in the hierarchy of appeal courts? And how would you fill that role?
I would, in practical terms, it will be the final court of appeal in most cases. But on matters of general public importance or on constitutional matters, it may very well serve as an intermediate court of appeal. In its function as an intermediate court of appeal, I think one of its tasks would be to present judgments which crystallize the issues as well as possible, because even if the SCA's judgments in such matters are not the final word, I think they can provide assistance to the Constitutional Court when it decides. And I think it's probably particularly important in the kind of case that may go further, that one should have at the SCA judges who are sufficiently strong-minded to, if necessary, state their opinion separately or dissent. Because if it goes further, those views in particular may be important, even if they're not upheld. So I certainly don't see that the SCA, like all courts, it is, as Mr. Mpofu pointed out, all law, common law, customary law, all of it finds its force now in the Constitution, and it does permeate everything, and it permeates the SCA's work as well. But the SCA is not likely to be the final word on the big constitutional questions, but it has an important role in perhaps getting rid of superfluous issues in the lower courts and presenting what is really the important matter for decision by the Constitutional Court.
The second question relates to your, please indicate if you can't answer this question for the reasons that you have explained earlier in relation to the other question that the President asked you. In the Western Cape has had its problems. I'm talking about Western Cape High Court. And there was an occasion. This was, I'm so sorry to just, there was an occasion when certain judges of the Western Cape refused to sit with another judge of the Western Cape. Were you part of that group?
I was.
And do you think that was appropriate?
We believed in good conscience that it was. We found ourselves in an impossible position. In subsequent, there was a complaint that was dismissed by the JSC, subsequently made against us for doing this by a Mr. Thabo Mkwakwa, who's quite an active political commentator on Twitter, but he lodged a complaint against us, and that complaint was dismissed. In responding to that complaint, we recognized that views may differ as to whether it was a position we were entitled to take. We felt we were entitled to take it. I accept that views may differ on that. In reality, what happened is that after we expressed that position, the judge president wrote to all the judges stating that he thought our attitude inappropriate, and he trusted that if we were allocated with the judge in question, we would not refuse to sit with him. Perhaps some real politic prevailed, because subsequent to that, he never allocated any of us with the judge in question. So push never came to shove. But what I can assure you is, and I think you know from the caliber of, I don't talk now here about myself, but Judge Desai, Mir, Davis, and others, Bozilik, we wouldn't have adopted that position unless we felt strongly in conscience that it was the right thing to do.
I have a limit of 2 questions. Thank you. Thank you, Chief Justice.
Thank you, SC. Honorable Muimam.
Thank you, Chief Justice. Good evening.
Good evening.
Judge Rogers. I just have 2 questions. The first one, if my memory serves me well, you refuse to interdict the swearing. You refuse to grant the interdict to prevent the swearing in of cabinet ministers following the late night reshuffling. I think it was in 2017.
Yes.
If you could probably just give a reflection as to why did you refuse? Did you think that it was going beyond what the court can do? And then the second one relates to the, if my memory also serves me well, the matter that involved the Democratic Alliance training SADC, where the order was that for the board and also for the investigation to take place, the former CEO, Mr. Mucheni, must be suspended. If you could probably just give a reflection to whether was that the role that the court was playing in terms of promoting good governance in the second instance?
Yes.
Thank you.
In the case of the cabinet reshuffle, as I recall, the cabinet was due to be sworn in later on a Friday evening, and I recall that I was the senior of 2 duty judges, and it came before me as an urgent application. And given the nature of the case, I made sure that the other duty judge, who's now Judge Villa, sat with me. So we heard it as 2 judges. We had very limited time, but my recollection, I think that was a case that arose at some stage after the judgment of the Constitutional Court in the Otto case, where the Constitutional Court emphasized the strict limits on interdicting executive action. It seemed to me that the presidential act, or the act of selecting your cabinet and swearing them in, was so close to the heartland of executive action that it would take extremely powerful evidence. I didn't discount the possibility that with a smoking gun of fraud of some kind, one might be able to do something about it. But I felt it was really the sort of area where you'd have to have exceedingly powerful evidence, and on the limited facts we had, it didn't rise nearly to that threshold. I'm afraid my memory has gone a bit dim on the case of the DA versus Mr. Motsoeneng. That was again a case I sat with Judge Lekranji, and we refused leave, and as far as I know, it was not in fact taken any further, but except that it was clear that there was widespread rot in the senior echelons of the SABC. I haven't revisited the judgment. I think in a position like that, where one is dealing not with the president and his cabinet, but with a parastatal organization and the conduct of its senior executives, one is some distance removed from the heartland of executive power. And the evidence was certainly powerful enough there to justify the court's intervention. It was a review application. It wasn't, I think this is the other thing, it wasn't an interdict. It was to finally determine whether what had happened was lawful or not.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you, Honorable Moima. Commissioner Tsepe.
Thank you, Chief Justice. Good evening.
Chief Justice, Minister Lamula here requests to be added.
Thank you. Good evening, Judge
Yes.
Rogers.
Good evening, Mr. Chair.
Lovely to see you. Judge Rogers, I have two questions for you. The first one relates to item 20, which is in page 10, about your current position on the Competition Appeal Court. You say that you want to retain that position, or you're hoping to retain that position. I wanted to understand, why would you want to do that? Yeah.
I think it's been a problem with the Competition Appeal Court from inception, that it has lost good people to higher courts. Judge Dambuza, Judge Milan, Judge Zondi, Judge Mshlanta, a number of them have gone on, Judge Chiki, have gone on to higher courts. I think it's unsatisfactory that you have a Competition Appeal Court where within a matter of 2 or 3 years, you might lose good people to higher courts. But at the same time, I don't think you will attract good people to the Competition Appeal Court if you say, well, since you're there, the path is closed to you for any further promotion. So when I said what I did in item 20, it was not that for my own sake I desired to hang on to doing competition appeal work. It was that for the sake of the continuity of the court, I would be willing to take on 2 or 3 appeals in the Competition Appeal Court annually. And as I say, my assessment of the workload of the SCA is such that I think I would be able to do it if it were scheduled during recesses. Obviously, it would need to carry the SCA president's approval, and there may be a statutory provision which needs to be amended. I think at the moment the Competition Act says that a judge of the Competition Appeal Court must be a judge of the High Court. I'd always understood that one was dealing with a case of the more includes the lesser, in the sense that, well, you have to at least be a High Court judge. That might be wrong, but I think it could be clarified so that judges in the SCA could, with competition experience, could from time to time sit in the Competition Appeal Court, and that is certainly something I'd be willing to do.
Or we shouldn't have amended the Constitution to take away the jurisdiction of competition matters from the SCA. And that was an aside, Chief Justice. I apologize for preambles. I know you don't like them. Just the last question, it relates to, I've noted the work that you do and quite grateful regarding training of advocates at the bar that you continue to do, and even the letter from the bar to that effect. What I wanted to find out from you is if there is any work that you do in terms of transfer of skills to judges, particularly Black judges and women judges in particular, in the work that you do.
I think it would obviously be paternalistic to take the initiative in anything of that kind, but I've frequently been approached by judges, including black judges, both in the High Court and in the SCA. Several occasions in the SCA, black judges have asked, who are the scribes, have asked me to review their drafts before they are circulated. And that also happens in the Western Cape. And I think people know that my door is always open to debate issues, and I do a lot. It's not a formal program of skill transference, but insofar as commenting on people's judgments and in that way, or debating issues with them without actually looking at their draft, I do that. And I can say I think from comments I've received and from encouragement I've received from African colleagues, for example, in the SCA, I believe they find that I'm able to do it in a way which doesn't appear condescending. And I'm able to raise my comments or suggestions or changes in a way which doesn't give them any offense.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you, Commissioner Tsepe. Commissioner Barnard.
Thank you, CJ. Just quickly, Judge Owen Rogers, I've seen in Carter matter, banking matters, you also referred to some other matters, and I've observed in court when you dealt with, still in the Cape High Court, even matters where the attorneys or the advocates are maybe on the wrong side of the law, you have a way of treating them with quite a dignified manner. What is your philosophy about litigants and particularly young practitioners that appear before you?
I think the days where there were judges that advocates were afraid of appearing before is not remotely compatible with the democratic era. It doesn't promote the administration of justice. Obviously, the more senior advocates, one can perhaps engage in debate in a slightly more robust way, but junior advocates or even more senior advocates who are diffident or not lacking in confidence, I think one must treat all people with dignity and respect, and particularly those sort of people need particular care. And if I may say, it also extends, as often happens in high court work, to litigants who appear in person, particularly in bond foreclosure cases. One often has the person whose eviction is sought appearing in person. And I think the way one deals with those litigants is also important. I also think it extends not only to how one deals with people in court. I think it also goes to what one says in one's judgments. I don't think there's ever cause to be cutting or derogatory about a judge in the court or quo or about an advocate in the case. All people will realize where they've gone wrong if they get overturned. It doesn't require any nastiness, and I don't think it has any place.
Thank you so much for that. Thank you, Chief Justice.
Thank you, Commissioner Barnard. Prof.
To your right, sir. Good evening.
Evening, Professor Schlemmer.
It's nice to see you. I think I was present at one of your very early interviews in the early 2000s, whatever it was. In any event, when I read your judgments, I'm quite impressed by the additional type of research that you do. And to that extent, I would like to know, we've heard from some of the other judges that they have to pay for their own access to data or to information. I see you are a member of the library, or you are responsible for the library in the Western Cape Court. Are the libraries in the Western Cape at the SCA sufficiently equipped to assist judges nowadays to be able to do proper research and to write scholarly judgments, as I like to call them?
The Western Cape has its own. I mean, we haven't had a qualified librarian in the Western Cape for about 6 years. So we have an administrative assistant who's effectively running the library. So when the selection of new books is something that falls to me, and budgetary constraints are obviously there. In the SCA, I have not served on any library committee. I obviously use the library a great deal. I don't know how much better their budget is for purposes of acquiring material. I think they have from my recollection of the SCA library, they have a far more extensive collection of journals. Probably, strangely enough, a less extensive collection of up-to-date textbooks than the Western Cape High Court, but a better selection of journals. I think a great deal of the research that one does, as you know, there's just so much information now available on Safley and Bailey and Aurstley and Canley. One can get at least all the law reports from around the world at the click of a button. Sometimes if there's an article that you want to read, you go online, you find, well, somebody's put it online and it's there. Otherwise, a researcher can, I've never found in the SCA, I haven't called for obscure material very often, but when I have, it's always been produced. I think they have arrangements with the Constitutional Court to get material.
Okay, so in essence, you think there is enough material available?
Yes.
Thank you very much. I'm covered, CJ.
Thank you, Prof. Honorable Minister.
Thank you very much, CJ, and good evening, Judge.
Good evening, Mr. Lamola.
Yeah, I see you want to take the Queen's badge from my silk colleagues here on my left, Commissioner Mpofu and Commissioner Madonsel. I want to ask you about this article that you wrote about the silk status. There's a striking paragraph there that strikes me very hard, because in one of the arguments you argue that one of the difficulties with the silk status, why you argue that it must be removed. I don't know if you still hold to that argument, because it was in 2004 first, you might have changed, but you speak about the selection criteria, which is a bit difficult and so forth, which is what we are currently grappling with the Legal Practice Council and all the bars across the country. What do you think? Why do you think this silk status must be taken away if it's still your view? Do you think it can help us with transformation of the legal profession?
I'm doubtful of that. My personal view remains that I don't think that silk is a helpful system, but I've long since given that up as a serious topic to pursue, because the vast majority of members of the bar are in favor of keeping it. In regard to the criteria, I suppose it's a little bit like the work the Judicial Service Commission has to do. You have to evaluate people. But I think it's invidious where some advocates, say 10 or so senior advocates at a bar, effectively are evaluating their colleagues as to whether they are good enough to get a certain status. And I just find, I served on a silk committee 3 or 4 times, and I found it dreadfully difficult to apply. There were people that you liked, maybe you didn't know enough about them, but your impression wasn't that they were sort of above the ordinary, which is more or less what silk is meant to be for. I think as a means of transformation and improving the representativity of Black people, and particularly African people at the bar, and for that matter, women, I think there are other mechanisms that are likely to be far better than silk. And I think that has to do with training, financial support to help young advocates bridge the 2 or 3 years when they start out at the bar, when the income may be little, until they are on their feet. There are other briefing initiatives. Unfortunately, I know these initiatives have not been spectacularly successful, but I suspect that if you look at because I was asked at my last interview about the Cape Bar, I got information from the current chair of the Cape Bar, and it still looks depressing when you look at the demographics across the whole bar, which is about 494 members, I think, in the Cape, or even just the non-silk members, who I think are about 380. Unfortunately, what one doesn't see are the statistics for the demographics of people who have only been at the bar 10 years and people who have only been at the bar 5 years. Because when I look at the pupillage intake at the Cape, for example, about 60% of the pupillage intake this year, or sorry, that was in 2020, were black. And I expect that the representativity is improving at the lower rungs of the bar. But there are a lot of people, 20 or more years of experience, who will carry on practicing till they've been 40 or more years at the bar. That's not going to change by the sorts of initiatives I'm talking about. What we should be directed at getting young women and black people, particularly African people, into the bar and staying at the bar. That's the important thing, that they shouldn't fall away because they don't have money to survive.
So don't you think the reason the practicing advocates or the profession does not take this debate forward is because they want to preserve the status quo?
I don't think that, you mean specifically silk or transformation initiatives in general?
The silk one in particular, because I mean, one of the objectives of the Legal Practice Act was to fuse both professions and to come up with a number of initiatives. Some of them is what you're talking about. So as you're saying, there is no appetite for this debate. Is it not because you think they just want that whatever that is there must remain like that?
I've been out of bar administration for about 15 years, but from the information I have, the transformation committee at the Cape Bar, for example, I think is 12 people, and I think 8 are black people, not all African people, but black, and the rest are white people. The Silk Committee is likely to be that's the committee which assesses the silk applications and applies the criteria and makes recommendations to the Bar Council. And in my experience, the Bar Council always accepted the recommendations of the Silk Committee. That Silk Committee, in my day, and that was in 2004, was at least half black. So if senior practitioners are using it to keep other budding senior counsel out, it's across the board. But I personally don't think that is happening. I think the bar knows that it would be better off being able to show more people, more black people and more women coming through as silks. I think they know that it's a point of criticism. I don't think they're trying to keep them out.
Okay, no, that's fine. Maybe if you want to answer, you could still. I can state that on my table as we speak, I'm sitting with the silk that I'm processing for the president, and they are still depressing as they were depressing when you saw them some many years ago.
Yes.
Thank you very much, CJ.
Thank you, Minister. Judge Rogers, thank you very much, sir. You're excused.
Thank you very much.